on repeat interlocutory applications preclude her application for interim interdict pendente lite aimed at prohibiting the National Assembly from continuing with the impeachment process. If the court is with us on that, then the relief against the National Assembly need not be considered on its merits. However, we must cater for the contingency that the court is against us. And so in the alternative, we will deal very briefly with the outer requirements. The reason being, we understood our learned friend yesterday to concede, contrary to his client's position in the affidavits, that outer applies. He preferred the refinement in the Gordon case of outer, but it's essentially the same line of decisions, and the principles on which we rely are indistinguishable as between those two sets of cases. Having done that, we shall explain why in our submission the application for an interim interdict pendente lite prohibiting the Assembly from carrying on with the impeachment process does not meet those requirements. While dealing with that, we shall also deal with the reliance on Rule 89, the sub judice rule, which is one of the grounds for the interdict which is sought. As my learned friend Mr. Masuku developed the argument, that in his submission stands separately from the outer requirements.
Let me just check. I don't see, I didn't call on Advocate Masuku. Just check whether he's online.
My Lord, yes, he indicated to me that he was going to assign Mr. Simelane for the first part. I don't know if he is online.
Mr. Simelane is on.
Thank you, my Lord.
Thank you.
Then we shall deal with the alternative claim, the claim in Cred 2 of Part A. That's the claim for an order suspending the Constitutional Court's dismissal of her challenge to NA Rule 129V, the one providing for the appointment of a judge to the independent panel. Our contention is that that's a non-starter for reasons that we shall explain.
Can I just ask you on that point, when we deal with that, it's just to take us to the page in the record where the application is to be found, the new application in the Constitution.
Could I do that right away, just to...
Yeah, because when we left here last night, I left all my documents here.
Yes.
And I tried on my laptop in the course of the night to trace the document, and it was difficult.
Needle in a haystack. The reason is it's Annexure PN12 to Annexure PCA1 to Advocate Mkhwebane's latest affidavit. It's in Volume 2 of what is now referred to as the supplementary record, or the interlocutory applications record at page 108.
Thank you.
So, in the alternative to a conventional interim interdict pendente lite, she has this application under paragraph 2 for an order suspending the Constitutional Court's dismissal of her challenge to Rule 129V, and that's based on, in the first instance, Uniform Rule 45A, alternatively Section 172(1)B of the Constitution. Our contention is that the application is a non-starter. In other words, it's incompetent with respect. Alternatively, it should fail for the same reasons her claim for an interim interdict pendente lite should be dismissed. Then there is a discrete order sought against the Speaker, which is an order directing that she withdraw her 10 March 22 letter to the President. We'll deal with that. And lastly, and somewhat unusually with respect, we will deal with her claim for personal punitive costs against the Speaker. Why I say somewhat unusually is my learned friend didn't argue the point yesterday, and he seemed to reserve the right to address argument to your lordships in reply for the first time. That puts us at something of a disadvantage. What we will do, however, is we will focus on the case made out in the papers, the founding affidavit, and in my learned friend's heads of argument. If something else arises, we may seek your Lordship's leave just to file a note afterwards. If, in other words, he raises something else which is not on the papers. We'll also deal with the proper costs order to be made if the present application against the NA is dismissed, as we submit it should be. Your Lordships will appreciate from what I've said that, save to the extent that it is relevant to the claim for an order directing the Speaker to withdraw her 10 March letter to the President,
there seemed to be a problem with the in-house recording. Because we are recording on Teams platform as well. And customarily, arguments are not recorded on the official system. So in the meantime, we're going to continue. We will record on the Teams platform. And if you can ask for them to reset on that side, because we'll have a backup recording on Teams.
Thank
so
you.
You may proceed, Mr.
Thank you, my Lord. I was making one final observation, and that is that the issue of whether the inquiry has commenced for purposes of Section 194.3a is not directly relevant to the case against my client. It's indirectly relevant because the contention that it hasn't commenced goes to this order directing the Speaker to withdraw the 10 March letter to the President. I shan't accordingly dwell excessively on that. My learned friend Ms. Pillay obviously has to deal with that, and I don't wish to duplicate the argument that
She
you...
developed a number of alternatives
Yes,
in her head.
indeed.
That's
That then brings me to the interlocutory applications, and as I understand the situation there, it's in my note, pages 3 to 5. There is no opposition to the interlocutory applications by any of the parties to have further affidavits admitted in evidence. There were affidavits, for instance, in the run-up to the hearing, or the initial scheduled hearing date, and in the run-up to this, and there's no opposition. There wasn't a formal ruling yesterday. I'm going to argue the case.
speaking for myself, and I'll just check with my colleagues. I don't think we need to hear any argument on the admission of the affidavits. It's a striking out that might be relevant for some of the parties.
Thank you.
There's agreement with the bench that all the applications for further affidavits that is filed, that should be condoned, and we can proceed.
Thank you very much. That leaves one interlocutory application which affects my client, which wasn't argued yesterday, and was it's part of the application brought in Advocate Mkhwebane's replying papers to strike out portions of the papers, the answering papers. In the case of my client, it is about 10 paragraphs 30 to 40 of her answering affidavit. My learned friend didn't argue that yesterday. It's addressed in paragraph 5 of the note on page 3 with reference to the argument in our heads, which is more detailed. We stand by that and have nothing to add.
And Mr. Mpofu also obviously his heads, so and he indicated yesterday abandoning any of the arguments that's taken place, and we'll deal with them on that basis.
Thank you. That brings me to the 6 key facts. I identified 4 in the note, and I wish to add 2 very briefly to that. Could I ask the court to turn to page 11 of the note? It's part of the in limine section, page 11. These are put up as 4 factual building blocks of the in limine points, res judicata, etc., but the facts are cross-cutting. There's 6 of them. So the first one is that on the 4th of February 2020, Advocate Mkhwebane launched case number 2107 of 2020 in this court. Now, like the present, it was an application in which she sought 2-part relief. In Part A, she sought to restrain the National Assembly from continuing with the impeachment process, initiated by the same motion of Ms. Mazzoni MP, which is currently before the Section 194 Committee. And she wanted that order until her challenge in Part B to, amongst other things, the constitutional validity of the new rules had been finally determined. One of the grounds on which she sought to interdict the impeachment process, which was supported by the ATM, the 16th respondent in that case, was its continuation would breach National Assembly Rule 89, in other words, the sub judice rule, which provides...
now the 11th respondent
in this matter.
represented by Mr. Masuku before us.
That is correct.
Just for completeness sake.
But the important thing, for purposes of res judicata, is that all political parties represented in the Assembly, all of them, were respondents in that case, as they are in the present matter. So Advocate Mkhwebane was there, the Speaker was there, the Section 194 Committee Chair wasn't there because that committee had not been established yet. The President was there, and all the parties represented in the NA were there.
And the President divided the decision according to the judgment.
That is correct. I would ask the Court, you don't have to do so now, to compare what one finds in the judgment of His Lordship Mr. Justice Saldanha, being the quotation from the Notice of Motion at page 589 in the Bundle of Authorities, paragraph 3,
I have in fact done the comparison last night.
with the relief sought in this matter. And essentially, as far as the interdictory relief is concerned, the Mdntv lite, there is no practical difference between the order interdicting and prohibiting the first respondent, that's the Speaker, from taking any further steps in the implementation of the process envisaged in Section 194 of the Constitution under the rules, and the relief sought in paragraphs 1.2 and 1.6. Why do I say that? When the first case was brought, my learned friends referred to a 17-step process. That was the analysis that was done in the answering affidavit. We were some way down the track, if I can call it that. What had happened at that stage was that the Speaker had certified that the notice of motion was in order. That was under Rule 129S. What had to happen next was that a committee, the independent panel, had to be appointed to consider whether there was prima facie evidence supporting the charges and to advise the Assembly. So the next step that had to be taken was a step by the Speaker, which would be the appointment of the independent panel, which would then do its work, and there are certain rules relating to how it had to work, 129X, 129V, and then its report would be considered by the Assembly, which, if it decided that a Section 194 committee had to be established, would then so resolve, and then I'll come in a moment to the parts of the rules regulating how that committee must function. So we were at the point before the appointment of the independent panel. That's why the relief was directed at stopping the process there. The Speaker can't take the next step. But the idea was to stop the process there. Now we're further down the track. The Assembly has established the committee. The committee has met. The facts are common cause. They set out in the Speaker's affidavit. There's a factual chronology, and I'll give you the references later on to the facts, the paragraphs in the answering affidavits which you can accept as not being disputed as far as the facts are concerned. The interpretation of those facts is another matter. I'll give those references to the Court if it will assist. But we're further down the track. Now the focus is on, obviously, an attempt to stop the committee. But the point is it's still stopping the process. So we see references here to 1.2, prohibiting the Speaker or the Assembly from authorizing the commencement or performance of any functions of the committee established in terms of 194. And para 1.6, the first to third respondents prohibited from taking any further steps or performing any acts aimed at commencing or proceeding with the process envisaged in 194.
So that's the issue.
That's the issue. It's the same. They just wanted to stop it at an earlier stage, and they failed. And now they want to stop it again. And in a moment we will be addressing submissions to the court saying you can't do that. You've tried. Pending what? It's pending the outcome of the Part B challenge, and as I shall demonstrate in a moment, these current rescission proceedings in the constitutional courts are aimed at trying to keep alive an aspect of that challenge, the Part B challenge, the challenge to Rule 129V. We're in the same boat as we were before. A full bench, differently constituted, considering the same question. And the question is that legally permissible? And
I'll ask you this. There was some debate with your colleagues yesterday. Are you in agreement with me with my understanding that issue is stopped has been fully assimilated into our movement?
Yes, it's undoubtedly so.
I don't think there's any question about that.
Undoubtedly.
But there are some judgments that say the court may come to the rescue of a party where issue stopped is raised under certain circumstances and it will be grossly unfair.
Unfair, yes.
That's how I understand it.
And I respectfully agree with that proposition. So what's grossly unfair about allowing the process to continue, I ask rhetorically, after the Public Protector has had her day up to the Constitutional Court on her challenge to not just the constitutionality of the rules, but the Speaker's application of the rules, which is what some of her counter-application was and the cross-appeal was considered with. Fundamentally,
so I understand it properly, is your view also that issue estoppel is essentially concentrates on the sameness of the issue? It's irrespective really of the remedy and course of action or the relief that a business has.
yes, the parties must be the same and the issue must be the same. And we've identified what the two crucial issues are. This court has read the judgment of the previous full bench that dealt with it. In paragraph 32, the first one was whether the continuation of the impeachment process before the proceedings flowing from case number 2107 have been finally determined will breach the sub judice rule. The second is whether the NA should be precluded from continuing with the impeachment process until a challenge to the constitutionality of Rule 129V has been finally determined. That was a component, that challenge to 129V. His Lordship, Mr. Justice Delama, will well know because he heard that case. That was one of many points taken. That there were a welter that were dealt with. I'd like to retrofit it this way. Let's assume against what I've contended that we're dealing here with a second interlocutory and not with a final judgment to which either res judicata or issue estoppel applies. Well, what does our law say about that? We deal with that on page 11 in paragraph 33. 33.1. There is a general reluctance, and this is the Constitutional Court speaking, approving a case called Mayer and Mayer in Zondi. The reference is given. To allow the variation of interlocutory orders granted by courts, unless the facts have changed in such a way that had they existed at the time the interim interdict was refused, the granting of the interim interdict would have been justified.
We don't regard the fact that the committee has now been established and, according to the rationale of the respondent, has commenced with its work as a substantial change in effect.
Not at all.
To affect the issues.
Not in the slightest. It is because the reason, Justice Delama, is this. This case is not brought because of the relief is not sought because something has happened in the committee, which is she's unfairly not been allowed to cross-examine someone or whatever. The criticism directed against the committee is at one thing and one thing only, and that's they've decided to carry on with their work. And they're bound to do that. Why is that? Well, 1943 empowers and obliges the committee to do this. It's one of those provisions which is a power coupled with a duty. 237 of the Constitution says that when duties are imposed, they must be performed diligently and without delay. And the rules of the National Assembly make it abundantly clear. In the new rules, and specifically the parts which are not impugned or sought to be impugned by this rescission process is how I'll describe it, because it involves more than one rescission application. A copy of the rules is in volume 7, NMN3, bit of a tongue twister. The rules relating to the committee are to be found from page 687 onwards, halfway down the page. Committee for Section 194 inquiry. That follows on 19129Z2, which refers to in the event the Assembly resolves that a Section 19 committee be proceeded with, the matter must be referred to committee for a formal inquiry. 129AA then deals with the establishment. 129AB's composition. And I pause to mention that the only function given to the Speaker in relation to the work of this committee is there in 129AB1. Namely, the Speaker determines how many members shall be on the committee. And we know that she ultimately determined 36 people in this case. From then onwards, the committee takes over. 129AC, the committee must elect one of its members as a chairperson. 129AD, its powers and functions. It must proceed to conduct an inquiry to establish the veracity of the charges and report to the Assembly. Sub 2, ensure that it is conducted in a reasonable and procedurally fair manner within a reasonable time frame. Sub 3 is the Audi provision. The proviso to that is the one which was severed by the Constitutional Court. And 4, for the purposes of performing its functions, it has all the powers of parliamentary committees, as provided for the Constitution, the applicable law, and these rules.
Now, my question on that is the issue was raised yesterday about Mr. Dianchi
Waking up in the morning.
deciding on his own,
Yeah.
A, to suspend on the advice of Mr. Tsinoli, and then secondly, reconvene
Yes,
when he woke up one morning.
Yes.
That's the meeting of all the twos,
yes,
2nd of February 2022 meeting.
yes.
And in reading sub 4 of 129AD, I'm thinking there must be rules that
Yeah.
are not placed before us as to how committees function and how meetings are called, etc.
Your Lordship has put your finger on the problem here. Why are those rules not before you? Because I submit you will look in vain for either of those points in the Public Protector's papers in this case.
Now, I couldn't find it. I went searching. You would have noticed that this was lying open in front.
It's
of me.
just not fair, my
You
Lord,
can-
for a point. That was a big point. More than half an hour's argument directed to it. But where in the papers is this point taken? Had the point been raised, Mr. Janchi would doubtless have referred the committee, the court, to a couple of rules, National Assembly rules. NA Rule 164, Sub A, the chairperson of a committee may interrupt or suspend the proceedings or adjourn a meeting. Or 161 read with 2A. The committee meet whenever necessary as determined in accordance with the rules and the decisions, directives and guidelines of the Programme Committee in accordance with Rule 210. A meeting of a committee may be called in terms of Sub-Rule 1A by the chairperson of the committee. Then further provisions about 1/3 of the members can call a meeting, as one would expect ordinarily. The Parliament is a sophisticated deliberative body, very sophisticated. There are rules in the Constitution. There are, in other words, provisions of the Constitution dealing with how it functions, and it obviously has rules. The Assembly has rules, the NCRP has rules, and there are joint rules. These matters would have been canvassed. It is not a question of Mr. Jantji having done something wrong. He did something which was obviously right. He had accepted the advice of Mr. Tsenoli, the acting speaker, not to convene a further meeting of the committee while the Constitutional Court proceedings were pending. And the reasons for that are explained in his affidavit to the Constitutional Court. The relevant excerpt is attached to the Public Protector's papers, and it's also quoted in the Speaker's answering affidavit. Essentially, it was that if the things carried on in the meantime and the Constitutional Court was against the Speaker on the 2 points which were taken on appeal, then not only would a whole lot of stuff been done which would not have been validly done if the order of unconstitutionality in relation to Rule V was confirmed, because that operates ex tunc, but the hearing of oral evidence would have started and witnesses would have been called under circumstances where the committee would have been obliged by 129 AD3, the proviso, read with Section 18 of the Superior Courts Act, not to allow her legal representatives to participate in the committee. And that, in those circumstances, Mr. Tsenoli gave the advice with which Mr. Jantji accepted, and my learned friend seemed to agree that that was the right thing, to suspend. But then a strange thing happened, and that brings me to the second key fact. So the Constitutional Court hands down a judgment on the 4th of February. And it says, in effect, the challenges to the rule are bad except for one of them, which is of prospective effect only because the hearings haven't started. Paragraph 110. I'll get to paragraph 110 and its implications for the debate about 194.3a briefly later. And it's clear on a reading of that judgment that the Constitutional Court signalled through its urgent dealing with the case, its acceptance of the direct appeals, that it appreciated and expects that the process will now carry on. It made the point in its judgment twice, as I recall, that the incumbent's term ends in October 2023. And it said that if the court processes had run their ordinary course through the SCA, this SCA to the CC, that would tend to reflect adversely on our legal system, because this is a time-sensitive and important matter. And one mustn't lose sight of the fact that the charges against the incumbent are themselves rooted in strident, perhaps that's too strongly put, strongly stated criticisms, sometimes resulting in personal cost orders, which were not overturned by the Constitutional Court when those matters reached the Constitutional Court. But that's something I have no doubt that my learned friend Mr. Budlander will deal with. So we're dealing with serious charges of serious misconduct, which the Constitutional Court said must be considered by the committee. What did Mr. Jantji do? He convened a meeting of the committee so that they can consider what to do. And what happened at that meeting is described in his affidavit. And perhaps it's as well just to go there, seeing as so much is made of that. May I just give you the list of the passages in the affidavits where you'll get what essentially are the undisputed facts. They're summarized in the Speaker's answering affidavit in volume 6, page 552 to 566, paragraphs 52 to 75. That takes us up to the meeting on the 29th of March 2022. This is everything from the 16th of March 2021, when the Assembly voted to establish the 194 Committee. Secondly, they're described in Mr. Jantji's answering affidavit. That's in volume 8, 721 to 730, paragraphs 8 to 30. That's also up to the 29th of March because they were filed at the same day. Then they further described in a second answering affidavit by Mr. Jantji, which is in volume 11, 1046 to 7, 9 to 13. That takes us from 29 March up to the 20th of April. Then they described in the joint practice note, which I and my colleagues for the first, second, third and fifth respondents filed on 11 May. One finds that in the interlocutory record or the supplementary record, volume 1, pages 43 to 51, paras 3 to 21, and I point out that the correctness of that was admitted by Ms. Mkhwebane in her affidavit of the 15th of March, which is in the interlocutory record. May, I apologize. 15 May, at interlocutory record volume 1, page 10, paras 7. And they lastly described in the affidavit of Ms. Jonker for the DA, the latest affidavit, that is in interlocutory record 3, 264 to 7, paragraphs 20 to 30. That takes us from 11 to 14 May. So those are the key facts. Now this much discussed meeting of the 22nd, what I think was a carnival of illegalities or festival, sorry, a festival of illegalities. That's in Mr. Janchi's answering affidavit, which is in volume 8 of the papers. And if I could ask you just to turn, this is one of the few passages in the record I will take you to page 726. And the first point I wish to make is that every time there is a meeting of this committee, it happens in public, it is live streamed, and the links, the URL links are given in Mr. Janchi's affidavit.
That's where that one of those, I actually checked the links when the affidavits were filed.
Yes.
In one of the meetings, that's where the term Festival of Letters arose, and I don't know who said it, but somebody mentioned the word Festival of Letters.
Festival of Letters.
And that's where Mr. Mpofu got it from.
Okay, so he wasn't an original, as we used to from him. So at 7:26 to 21 to 23, this meeting is described. So firstly, Mr. Janchi says he decided to convene the meeting and that the committee resumed its work. What did they do? They considered the import of the Constitutional Court's decision of 4 February. They also considered a request by the applicant that the committee halt its proceedings until the ConCourt had determined an application for the rescission of part of its judgment and orders, which she intended to make. And now we see what it decided. It decided 4 things. Paragraph 22. 1, it resolved that there was no legal basis for it to halt its work and it had to continue with its inquiry into the charges. 2, it's in paragraph 23, it adopted a set of terms of reference governing the process going forward. 3, it resolved to identify evidence leaders pursuant to the terms of reference. And 4, it adopted a draft program as a working document, and that's the program which at that stage envisaged that evidence would be start being led on the 4th of May. So that's what the committee did. Now, what's wrong with that? I ask rhetorically. The Constitutional Court has dismissed an application for the wholesale invalidation of or confirmed the dismissal confirmed the dismissal of an application for the wholesale invalidation of the rules. It said, in effect, the inquiry can and must continue. And the committee was getting on with its business.
So are you saying that the committee was busy with its business? Mr. Zanoni then received information, and for want of another word, the pause button was pressed until such time as the judgment came from the Constitution.
That's what that
And then when the Constitutional Court judgment came, the pause button was no longer active.
Correct.
That carried on.
Yeah. And the person who could put that pause button was Mr. Janchi under Rule 164. He could suspend the proceedings of the committee. He did so effectively by not convening another meeting, exercising his 161.2a power, Rule 161.2a power. But you see, the problem is these points that this is somehow irregular were not taken on the papers, and it would have been explained to you had they been done. But
He
if
makes
one,
that point, and I pointed it out to Mr. Mpofu yesterday. At 726 in paragraph 20, he says, I accepted Mr. Chinoli's recommendation and consequently did not convene a further meeting of the Section 104 committee.
Mr. Janchi, in this affidavit and the others, as the Speaker has done also, they have given a matter-of-fact, dispassionate account of the events. What one reads here, there's no spin. This happened, then I accepted this recommendation, then the next thing happened and I convened a meeting of the committee. The committee met, that dealt with these things. You can view the proceedings of the committee on the YouTube. Everything happens in public because it's in the nature of the Parliament that it is a public forum. It's where our representatives meet to determine and deliberate on matters of national importance. I'll get to the claim for personal costs against the Speaker later on. It's strikingly at odds with what one reads in the affidavits as to what has actually been happening in the Parliament. Parliament has been trying to continue with this process despite challenges which have had the effect of slowing things down, and that's not just legal challenges, it's also the COVID challenge which created a significant damper, put a significant brake on all of its business, as it did on the rest of the country. So, my Lord, getting back to the facts, I'm weaving the submissions around the facts, as you'll appreciate. Go back to page 11 of my note. So, having brought this application for an interim interdict, pendente lite, on the 9th of October, the full bench of this court, the Lordships Saldanha, Steyn and Samela, refused to grant the interim interdict. The court, as His Lordship presiding pointed out to my learned friend, rejected Mkhwebane and the ATM's reliance on the sub judice rule in the course of its judgment. The reference is given, paragraph 108. She sought leave to appeal from the full court and then directly to the Constitutional Court. She didn't ask the SCA for leave to appeal. They failed. So the outcome of that case, the Part A, is therefore that the question whether she can interdict the Assembly from processing the motion for her removal from office pending the final determination of case 2107.
2017, I think.
Is it?
No, it is 2107.
Apologise. That case, the earlier case. That has finally been determined adversely to her. And it's on that basis that we submit, whether you look at this through the lens of res judicata, as we've submitted in paragraph 31 of our heads of argument, issue estoppel as in paragraph 32 of the note, or our law on repeat on repeat interlocutories, that she has, and she's not permitted to ask this court the same question again. She's not permitted to seek the same relief in these proceedings as she did previously. Just picking up on Justice Delama's question to me about changes in the facts. There have actually been significant changes in the facts since then. But in order to activate the court's jurisdiction, the changes have to be facts which, had they existed at the time when the initial refusal,
Favourable to the applicant.
that's correct, would have justified the grant of an interim interdict. Courts are not totally inflexible. They realize that things, circumstances, facts and circumstances change. But what's happened here? The process has moved further along. And I suppose if one were to look at it in a sort of myopic way, one could say unfavourably to her, That's the process in Parliament, because the Mkhwebane committee found that there is prima facie evidence to support the charges. The Assembly accepted that advice and has constituted the 194 committee, and she's now in jeopardy in the formal sense envisaged by 194, because the committee has been established to conduct the inquiry into the allegations against her.
Let me ask you this. What about Mr. Mkhwebane's submission that there may be facts which are unfavorable to, which are in favor of the applicant, namely this whole issue around the SMS?
I'm going to deal with that in some detail in a moment. The short answer to that, which I shall elaborate on, is that one needs to distinguish very carefully between speculation and the facts which one knows from the record and the inferences that one can reasonably draw from those facts. Inferential reasoning reaches a point where it might be entertaining around a dinner table, but it's not a basis for a judicial pronouncement. And with respect to my learned friend and his client, we have an application. Now, that aspect of the case is based on speculation and conjecture. But there are key facts that have changed adversely to her currently. Remember, the case was brought pending the final determination of her challenge to the rules. Well, by right, in an ordinary parlance, that was finally determined adversely to her on the 4th of February when the Apex Court delivered its judgment. Now she sought rescission of that judgment. And it is correct that that is a step which the rules and our common law provide for. The problem is, if one looks at the content of that application, as we have done in our papers, in our heads, and in this note, what one finds is that it is an impermissible attempt to relitigate points which were decided adversely to her. That's one of the problems, main problems with it. So, for instance, one of the grounds of rescission raised was the court misapplied its judgments in 3 earlier cases, Heath, etc. That's an appeal point. It's saying you got it wrong. That is not a basis for rescission, and the Constitutional Court has expressed itself recently very firmly about that.
You compare
Yes.
majority judgment.
Yes. The other problem with that application, which we've also identified, is that there are contentions that the Constitutional Court did not consider this, that, or the other aspect. But as we've explained in our heads, and it's in the note as well, I'm not going to, time won't permit me to go there, and I don't think it's necessary for a reason I'll come to in a moment. It's simply not correct. Frankly put, those allegations are not true. The Constitutional Court did consider those issues and decided them adversely to her. Now, that is not a proper basis for rescission. And if and to the extent the court has to peek into the merits of that application, the court will see that that essentially is the problem with it. The Constitutional Court made findings which are consonant with what I have now submitted to the court on the 6th of May, when it dismissed that application. It didn't simply issue an order dismissing the applications for direct access. In the supplementary bundle volume 1, at page 85, PN9, one has the order. And it contains reasons, albeit brief, for the summary dismissal of this application. And perhaps I should just put something else to bed while I am dealing with that. The rescission application, the first one, like the second one, was brought under Rule 18 of the Rules of the Constitutional Court, which deals with direct access. It is not a rule which makes any provision for the filing of answering papers by the respondent or replying papers by the applicant, unlike Rule 19, which deals with applications for leave to appeal. It says you must bring an application setting out your grounds, the nature of the relief sought, and whether in your submission as the applicant the case can be dealt with by the court without the hearing of oral evidence, and if it cannot, how such evidence should be deduced. That's what Rule 18.2 says. 18.3 says if any party wishing to oppose it must deliver a notice of intention to oppose within 10 days. 18.4 says after such notice of intention to oppose has been received by the registrar, or where the time for the lodging the notice has expired, the matter shall be disposed of in accordance with the directions given by the Chief Justice, which may include A, a direction calling on respondents to make written submissions to the court, or B, a direction indicating that no written submissions or affidavits need be filed. And then 5 says applications for direct access may be dealt with summarily without hearing oral or written argument other than that contained in the application itself. And there's a proviso which says that the court can't grant such an application if notices of opposition have been filed without first directing that written submissions be filed by the respondents opposing. So an application can be dismissed summarily on the basis of the application itself. That's the rules of the Constitutional Court. Now, the Constitutional Court justices are obviously well acquainted with that. They deal with literally hundreds of applications, either for leave to appeal or direct access applications every year nowadays. The caseload is astronomical after the amendment of the Constitution about 10 years ago. What did the Constitutional Court do? 2 months and 2 days after giving its judgment in this matter, the application was brought, the rescission.
No. Can you just, I see it's a spokesperson of Parliament. He doesn't have a voice here. Mute him, please. Can I just request, as yesterday as well, all participants, except the parties that need to speak in court, can you please mute your microphones? I know sometimes one forgets to do that, but please work with us. Yes, Mr. Fred.
So the Constitutional Court considered this application. The rescission application was brought on the 11th of March, a week after the judgment was handed down. And just short of 2 months later, on the 6th of May, delivered an order which reads as follows. The Constitutional Court has considered the application for direct access and rescission. It has concluded that there is no need for directions to be issued in terms of Rule 18.4, calling for written submissions and or answering affidavits. The Court has concluded that the rescission application does not establish any rescindable errors in the judgment. There are also no exceptional circumstances that warrant the rescission of the judgment. Therefore, the Court has concluded that the application should be dismissed, as no case has been made out for rescission. The Court has concluded that the application for direct access should be dismissed, as no case is made out for direct access. The Court has decided not to award costs. And then the orders follow, both applications being dismissed. This is an order which is signed by the Registrar of the Court, and stamped, addressed to all of the parties. It is an official act. In accordance with our law, the presumption of regularity, it is presumed to be valid until it is proven to be invalid by evidence adduced to a court. There are 2 proceedings in which that is potentially sought. The first is the second rescission application brought by the present applicant in the Constitutional
The one
Court.
on the 10th of May,
Indeed.
filed on the 11th.
And there are also, those submissions are echoed or repeated in this court, where one has a submission made in paragraph 29 of Ms. Mkhwebane's affidavit that the order is, there's a lingering suspicion around that order arising from the SMS, and I'll get back to that in a moment. But for the purposes of the eliminate point, what I wish to point out is this. The situation has changed materially adversely to Advocate Mkhwebane from that which obtained at the time that the Saldanha Court was considering this matter. Her challenge to the rules has been finally determined, and in one limited respect adversely to her, but that doesn't affect anything that's happened so far. The application for rescission of the final determination of that by our highest court has failed. So there is no jurisdiction in this court with respect to reconsider this application for an interim interdict suspending the parliamentary process from carrying on. That brings me to an issue concerning the second rescission application. Before I deal with the merits of that application, I'd just like to deal with its implications. Firstly, generally as regards the rescission order that was granted, and secondly, as regards the relief sought in this case. Because of course the relief, the centerpiece of the relief is the first rescission application. Let's just deal generally with the consequences. So what is the legal consequence of the bringing of the second rescission application? We allude to this at page 8 of the note in paragraph 20. And the first point that we wish to make is if one has regard to paragraph 155 of her founding affidavit in this case, in volume 1 at page 53, she conceded for purposes of Part A that suspension of an order impugned in a rescission application is not automatic, but may be ordered on the application of a party. She accepts that that's the law. So that's a legal concession. And she, as the court pointed out to my learned friend yesterday, she's seeking in paragraph 2 of Part B an order that the common law be developed to result in such automatic suspension. But, my lords, for purposes of this case, there is a concession that the making of a rescission application does not suspend the operation of the order sought to being rescinded. Now, that is a concession of law. The court is not bound by a concession of law if it is wrongly conceded. But we submit the concession is correctly made, and we refer the court to superior court practice. The references are given and the authorities cited there, but there are essentially three reasons why the concession is right. The first is found by Rujay in the United Reflective Converters case, that's referred to in paragraph 21.1. There is no substantive rule of law that an application to vary or rescind an order or judgment automatically suspends its operation. It's on page 8 of our note. The second is pointed out by Justice Mayer in the erstwhile tenants of Williston Court and others versus Luray Investments matter, paragraph 20. It's for that reason, it's because there is no automatic rule of law, that we have Uniform Rule 45A. That allows a party who wishes to have the operation and execution of an order that's the subject of a rescission application suspended, pending the outcome of the rescission application. You can go to court to get such an order. They're doing so in this case, in paragraph 2 of Part A. They've brought an application under Uniform Rule 45A. Now, you know we submit
can you check who that person is that keeps on having? It's Prof. Manju. I can see from here. Yeah, she muted herself.
So, a rule has been created to allow court to suspend the operation of an order which is the subject of a rescission application, precisely because the law doesn't have that effect. You have to come to court to get that relief under Uniform Rule 45A. We have submitted, though, that rule does not apply to orders made in rem. It applies to orders in persona, where the particular person, let's call it the judgment debtor, can seek relief. But where one's dealing with an order about the constitutionality of a rule of general application, that person doesn't represent any and all people who are affected by that. It affects all of us equally, at least to the extent that we're all subject or equal before the law. And the third reason, also given by His Lordship Justice Mayer in the Lura Investments case in paragraph 18, is this, is that when enacting the Superior Courts Act, the legislature gave specific attention to further steps in concluded litigation and what those further steps should be, the effect of them on the operation and execution of orders. I'm referring obviously to Section 18.1 of the Superior Courts Act. And it provided that if you apply for leave to appeal or leave is granted and you're on appeal, then that is the effect. But it did not add rescission, which it could have. It left, in other words, the position regulated by Uniform Rule 45A. So, where does that leave us as far as the present case is concerned? Could I ask you to just turn to the notice of motion? I'm working with the amended notice of motion, which is in volume 11 at 1018. And for I've already said that the relief which I'm addressing here is the relief aimed at suspending the proceedings of the Assembly, pending, in paragraph 1, the outcome of Part B. That's what the preface to paragraph 1 says, pending the finalisation of Part B, an interim interdict. Then in paragraph 2 it is pending the finalisation of B and or the rescission application. So let's just start with that. The rescission application in para 2. That has been finalised. It was finalised on the 6th of May. So you can draw a line through that. The fact that a rescission application has been brought in relation to that doesn't make it not finalised. It's been finalised. What about Part B? In the debate yesterday, my learned friend was taken to the part of Part B which correlates to the interim interdict stopping the parliamentary process. And there's only one part of that. It's paragraph 1.3 of Part B, declaring in terms of 172(1)(a) of the Constitution the conduct or decision of the committee to commence or proceed with the 194 removal proceedings while the matter is sub judice to be unconstitutional. And my learned friend said that the matter there is the rescission application. That was in answer to a question from His Lordship Mr. Justice De Lama. And that is right. It can only be that matter. Because on their hypothesis, the way they were approaching this case was, yes, the Constitutional Court spoke on the 4th of February in case 2107, but we've sought rescission of a key part of that, which if it's successful, and if the Constitutional Court then reconsiders that matter in our favour, will turn the clock back to before Justice Mkhwebane's committee was appointed. So you can't carry on, you have to go back and start again. That's the theory of the case for the applicant. And that's therefore why my learned friend was quite right to say that the matter in 1.3 is the rescission application. But now the problem with that is that the matter is no longer sub judice, because the rescission application has been disposed of. So where does that leave them? This is quite apart from res judicata. I think it was in Huckleberry Finn. It's up the creek without a paddle. There is no longer pendente anything. It can't be pending Part B, which is pending a rescission application, which is gone. So the implication of the dismissal of the rescission application on the 6th of May is profound. It's devastating for this application if you get to it on its merits.
Well, he says the 6th of May order to be read with the notice of motion is revived because of the 10th of May application.
I've already addressed that, my Lord. I've explained.
I'm just explaining
the reasoning, but
how I understand Mr. Mpofu's argument to say
yes,
nothing has really changed because we filed the new
I know,
application.
and
Now
the next one will,
again.
and the next one may come as well. He said that he's not ruling out anymore, depending on what further developments there are. But the point is this: I've explained why in our law the lodging of a rescission application does not ipso facto suspend the operation and execution of the order. It doesn't. You have to apply for it.
Well, the Constitutional Court in the Zuma versus the
Commission.
Secretary of the Judicial Commission of Inquiry, etc. That's the one in 891 of our bundles. Dealt with the distinction, the under 42 and rescissions, referring back to the old case in this division of Vivanathan, and accepted the analysis of Thringe in that case effectively, and dealing with some other issues as well that's relevant to our case,
including the importance of the finality of judgments.
Well, it's the introduction to that case. And the paragraph 1 reads as follows. It says, like all things in life, like the best of times and the worst of times, litigation must, at some point, come to an end. And then deals with the fact that the Constitutional Court is the highest court in the land and finality and so on. So that's the introduction to the judgment that sets the stage for the later analysis and dealing with rescission applications to the Constitutional Court.
My Lord, it's a second and now specific to how this pendente what in this application, fundamental problem for the applicants insofar as they're seeking an interim interdict against Parliament. Whether they approach it through the provision, the conventional interim interdict pendente lite in paragraph 1, or through this order suspending the operation and execution of the part of the CC judgment which altered the judgment of the Part B full bench here in one respect so as to keep that open, doesn't matter.
Well,
It's over.
the effect of the participation of a judge, that's the subject matter that the applicant is unhappy with and she wants to be rescinded. That will take the process back, the 194 process in the National Assembly.
Yes.
Because it will take the basis of the panel away.
Absolutely. That's
And that's the
theory.
argument.
Yes.
Whilst that is being challenged, we have the right not to be subjected to further process.
Yes. So
That's how I understand it.
that is the argument, and what they have to persuade you of then is that they have to persuade you of their prospects of success in rescission 2. It has to be a compelling case. I'll get to that now. And then they have to persuade you of their prospects of success in rescission 1. Those are the 2 peaks that you have to take.
That's if they get over your first point, the
If
res judicata point,
Yes.
and the multiple
Yes.
interlocutory applications.
Yes.
point.
So what I'm saying is that on this notice of motion as it stands, I'll go further and I'll say this. I'm going to deal with the merits of the outer interdict, and also the merits of this paragraph 2 in the alternative to this proposition. I don't want to be misunderstood. Because of our law on what the effect of a rescission application is, bringing of a rescission application is on the order sought to be rescinded, and because of the concession which the other side have made in para 155 of their finding affidavit in line with the law, the giving of that order by the Constitutional Court on the 6th destroys the basis for the relief sought. There is no rescission application. One can draw a line through the rescission application, and there is also no Part B as far as my client is concerned. I'm not leaving aside the interdict against the President, that's another matter. But paragraph 1.3, the matter is sub judice. One can draw a line through that too, because there is no matter which is sub judice anymore. It is over. There's now a new matter, which is rescission 2. But crucially, my Lord,
Decision 2 is
10 May.
It's interesting because it goes further than what was before the Constitutional Court under 2107.
Yes,
It now deals with
conduct of the Chief Justice.
It's at more than one place in the record.
Page 108 of the supplementary bundle. Is as
The relevant portion is on 109 of the supplementary as well as on 323
yes,
of the supplementary.
Yes,
And
touch
it
the
deals
deal.
with a few other matters as well.
yes. But the point that I wish to make is this: they've made only one amendment to their notice of motion. It's an inconsequential amendment. The replacement of in the word concerning with commencing in paragraph 1.6. This is in this court. They have not sought to amend their notice of motion to seek relief pending the outcome of rescission 2, where it refers to the rescission application brought under case number such and such. That was the first rescission application. One reads it with the founding affidavit.
So you say that the relief sought under A is pending the relief sought under B, that's on page 3, under paragraph 2 of the notice of motion, and that specifically states the
matter is
the application brought under on that case and the order of this court as amended by the Constitutional Court. So that is the 4th of February judgment.
yes. It's not just the words, the rescission application. One has to read the whole sentence. Brought under case number suspending the operation and execution of para 118 of the order in case number. It's the appeal, successful appeal against the one aspect of the Part B judgment in this court. They've not amended their relief to seek interim relief pendente rescission 2. They could have done that. They haven't. And if they try and do that in reply, we will strenuously oppose that, because they've known about that judgment since the 6th of May. They've filed further affidavits. They've made their bed. They must sleep in it. They're the applicants. We brought to court to face the relief sought in this notice of motion. I'd like to then deal with outer very briefly. This is now the alternative to these two fundamental points. There appears to be no dispute anymore between the parties that insofar as the conventional interim interdict is sought in paragraph 1 of Part A, that outer applies to that. My learned friend, as I indicated earlier, prefers the Gordon reformulation. We submit that that's a distinction without a difference. It's the Constitutional Court elucidating and applying a principle first formulated famously in the outer case. At page 17 in our heads of argument of our note, at paragraphs 42 to 45, we submit there are three key requirements. They can be reduced to the following. First, In the absence of proof of bad faith, corruption or fraud, the applicant must show a compelling case on the merits of the main case. The court must be convinced the main case is likely to succeed. My learned friend emphasised the likely to succeed part, but it did de-emphasise the convinced part. So a compelling case on the merit, convinced the main case is likely to succeed. A formidable onus. Secondly, the applicant must show they have reasonably apprehend they will suffer irreparable, irreversible and imminent harm if the interim interdict isn't granted, and they're ultimately successful in the main case, and linked to that, the absence of a suitable alternative remedy. And thirdly, if the applicant overcomes the first and second hurdles, they must show the harm they will suffer if the interim interdict is refused outweighs the harm to the separation of powers and the public interest that will ensue if the state is restrained, the organ of state, from performing its constitutional or legislative functions.
Can I just pause there? You've referred us to the duties of the National Assembly under 194.
Yes.
And it's a constitutional duty.
Yes.
An obligation. And then if one reads that with 237, the constitutional provision of 237,
Yes.
subject to the rights of the individual or institution to be dealt with by the National Assembly, they enjoined to perform those obligations, the constitutional obligations, diligently and without delay.
Yes.
Now, how does that affect the discretion that you have when you consider
Yes.
being bound by the Constitution to do certain things, your clients?
Profoundly.
National Assembly.
Profoundly.
So if you can just address us on that as well.
Yes. In the in paragraph 38 of the note, we quote the parts of the outer case which explain why there is a different test when it comes to restraining organs of state from performing legislative or constitutional functions than there is in the ordinary run of interim interdict cases. It's because, as the Constitutional Court explained in paragraph 44, beyond the common law, which is where these requirements were initially fashioned, separation of powers is an even more vital tenet of our new constitutional democracy. The Constitution requires courts to ensure that all branches of government act within the law. However, courts in turn must refrain from entering the exclusive terrain of the executive and legislative branches of government unless the intrusion is mandated by the Constitution itself. And the court added in paragraph 6, consequently, where a court weighs up the balance of convenience where that rests, it may not fail to consider the probable impact of the restraining order on the constitutional and statutory powers and duties of the state functionary or organs of state against which the interim order is sought. And we have outlined those duties in paragraph 54 and following. So the court must place in its proper context what's happening here. Section 42(3) of the Constitution provides that the Assembly is elected to represent the people and ensure government by the people under the Constitution. 181(5) says Chapter 9 institutions are accountable to the Assembly. And then we have 194(1), which makes provision for their impeachment, removal from office on specified grounds and in accordance with a specified process. And it follows from that every Chapter 9 office bearer is liable to be subject to proceedings of the kind in question. And as the Concord put it in the 4 February judgment in paragraph 37, impeachment proceedings are the means through which accountability and fidelity to the rule of law can be achieved. So the conduct of those proceedings in and of itself doesn't constitute an infringement of any rights in the Bill of Rights, but what is more, it is something which is part and parcel of the fabric of our Constitution. These institutions are appointed to support and strengthen constitutional democracy, but the incumbents, if they misconduct themselves, or are incompetent, or incapable of doing what they were appointed to do, can be removed. And they must be removed. It's part of what the Constitutional Court has referred to as democratic hygiene, that if problems arise with a particular incumbent of one of those three kinds, that this process be undertaken by the National Assembly. That's the choice that the makers of our Constitution settled on. It's a matter for the Assembly. The Assembly appoints, and within limits and for specified reasons, subject to supermajorities, the Assembly removes. What the Constitutional Court has also held is that there have to be rules for that process. Rules were adopted, and those rules are being implemented by the Assembly. That has, as I submitted, a profound impact here. In short, what we have in this matter is a rescission application. First, well, let's step it back. We had a challenge to the rules. The challenge has, to all intents and purposes, failed. The process can carry on, subject to one amendment effected by the High Court and confirmed by the Constitutional Court. 2, rescission of that decision was sought in a key respect, which, as His Lordship presiding pointed out, would turn the clock back to before the appointment of the Mkhwebane Committee. That has failed. The Court has seen what the reasons of the Constitutional Court are. The Court knows what our submissions are as to the infirmities of the rescission application, re-arguing points that they've lost, wrong accusations that points were not considered and decided when they were. Those are the essential 2 grounds of complaint that make up the 6 in the rescission application. Hardly surprising with respect that the application was dismissed. So we ask ourselves, with reference to outer, do we have a compelling case on the merits? Is the Court convinced that this main case is likely to succeed? The Court can never be so convinced with respect. The Constitutional Court has spoken twice on the matter. And that's a key link in the chain. We're trying to retrofit now. You see, we're way past that. And Advocate Mkhwebane is trying to turn the clock back.
Well, as I understand the argument from Mr. Mpofu, he says outer is not applicable. Got to go back to Sepagelo and then look at Sutherland J, as he then was, his judgment in Amabungani, and you read it together, and then the test is different. I'm paraphrasing, but that's the argument, and we have to consider that argument seriously, whether it's applicable here.
Well, there's two things to be said about that argument. I cannot think of a clearer case where outer applies. We are dealing here with a power entrusted by the Constitution to the Assembly alone. The President's function in relation to the actual removal is the formal function of effecting the removal if the Assembly decides after this process. The separation of power looms large, it looms huge.
But that is why I referred you to these provisions of the Constitution, yes. Because what we're asked to do is to restrain the National Assembly from performing these duties and obligations that they empowered to do and enjoined to do,
yes,
in terms of the Constitution.
Yes.
And it's dealt with by the Constitutional Court in outer.
And it is a compelling case is required for that. That has been tried and never succeeded in this court. We've cited the cases. There are 4 or 5 of them now, culminating, of course, in Part A of the present case. So if you're against me on res judicata, and you're against me on issue estoppel, then at least what I have in my favour is we have a finding of that court on this question: does outer apply?
Well, that's why I raised with counsel for the applicant yesterday the question of res judicata and comparing that to the judgment of the full court authored by Saldanha J. because it deals with the outer question from about paragraph 18 of their judgment and further. And he summarizes both arguments that we have before us. Your argument as well as Mr. Mpofu's argument, that was before that court.
And he not only concluded that it does apply, he went on at paragraph 72 and following, at 601 of the bundle, to apply outer in detail and analyze the strengths of the and weaknesses of the various challenges. There were many at that stage. And then he went on to consider the alternative remedy, balance of convenience, and particularly in that context, the impact on the separation of powers. So we are, the applicant is in bad shape. The Constitutional Court having spoken when it comes to the very compelling, the compelling case which she requires. But now we have a new rescission application. So there's a new order and a new rescission application, and all of that turns on the SMS of Mr. Abramji, and I'd like to address you on that.
How do you pronounce your surname?
My surname,
How do you pronounce it?
Breitenbach.
So it's not a Y.
Yes, oh no, I'm an EI, yes.
Okay. No, that's just an enlightened language.
Yes,
For those of us that know, that's seen the essence,
yes.
or whatever it is.
I don't think that there's anything of great moment turns on that. It
Yeah.
may have been a notarial mistake many years ago, but
Yeah.
not in my lifetime. So what we have is, in paragraphs 49, 52, 72, and elsewhere in her latest affidavit of the 15th of May, that's where the court must now look for a case in relation to, let's call it rescission 2. That's in the interlocutory record at pages 24, 25, and 30. And this is the case on the papers. The impeachment process in relation to her cannot be allowed to proceed before the finalization of the Chief Justice's investigation into Mr. Abramji's unsolicited SMS to me on Sunday afternoon, the 24th of April 2022. Now, we submit, and I'm at page 21 of the note, there are 4 reasons why that investigation should not or is not a reason to stop the Assembly from proceeding with the impeachment process in relation to her. But before I delve into those reasons, I just want to emphasize again, nowhere in this notice of motion will you find a prayer for an order that the NA not carry on with this process pending the outcome of the Chief Justice's investigation into the SMS. Nor will you find anything in this notice of motion that the Assembly not be allowed to carry on pending the outcome of the application for rescission of the dismissal of the application for rescission. So what I'm saying,
you're saying that
this is in the double alternative that I'm now making
they
these
have the
submissions.
opportunity to amend their notice of motion
Yes.
with all the new evidence, and they chose only to amend 1.6 by substituting consistent with commencing.
Indeed. So there are 4 reasons. These are now as to the merits. I'm now dealing with the prima facie case, the peak, which the court is enjoined to undertake if it gets to this point in the case. The first is,
What you say is, there's no peak. Once the notice is filed, we have to wait until it's heard.
so perhaps I should just read paragraph 155 of his client's founding affidavit.
That's my priority.
I've referred you to the cases which say that the mere filing of a rescission application does not have that effect. You need to bring an application under Uniform Rule 45A to suspend the operation in effect. But this is what his client says.
At that point, where are we now?
Yes.
Are we also entertaining an application in terms of 45A, or we have to wait until such an application is brought?
So what we have on the face of the notice of motion, an application in terms of 45A, it's paragraph 2, but it's actually pending a different rescission application. The application for the rescission of the order granted on the 4th of February in relation to paragraph 118 sub 2 of the Part B courts. But so we're in Alice in Wonderland world here, because of all the many steps, logical leaps that we have to make to try and work our way back into what's here in the relief. This is how I understand the argument, is they say you have to consider the merits of the latest rescission application, and then the merits of the other rescission application, and then ask yourself whether you're going to suspend the proceedings to cater for the contingency of the Concourt upholding the latest one and the first one, and then changing its mind on the merits of the appeal. That's where we're at, as I understand the case. But I say the notice of motion doesn't get them there, and that's a point that I've already made. But assuming that we are there, and for some reason it's important for this court to consider the case mounted on the basis of the SMS, I'd like to address that briefly. So firstly, why Mr. Abramjee sent this SMS to me, and whether he did so based on his own assessment of the situation, as he apparently alleges. I see this from reports of what he's told the journalist, and apparently also in an affidavit, or because he's received some information from inside the Constitutional Court, as Advocate Mkhwebane alleges or believes. Those are matters which have nothing to do with the matters to be considered by the Section 194 committee. The latter, what the committee has to consider, is confined to whether or not Advocate Mkhwebane has misconducted herself and or is incompetent for the reasons charged in Ms. Mazzoni's motion calling for her removal from the Office of Public Protector. The two don't overlap at all. The second thing is, whatever advantage Mr. Abramjee intended to confer on the legal team representing the Speaker and the Chairperson of the 194 Committee by sending that SMS, that was negated when the following day I disclosed it to counsel for Advocate Mkhwebane and the respondents supporting her, and to this court. So whatever was sought to be achieved was not achieved, but as your Lordship presiding correctly pointed out, it did cause significant disruption in that the case had to be postponed by agreement to get certain clarity from the Constitution, or to report the matter and to get clarity about the truth of the content of that. Because, as your Lordship presiding pointed out on that occasion, and as I've argued today, if the rescission application had been refused, that would have a profound impact on this case. One need look only at the notice of motion to know that. And Mr. Masuka very fairly conceded that in his remarks then and in his argument yesterday. The third point is that her founding affidavit in support of the second rescission application, one looks at that, it doesn't contain any facts as distinct from speculation, which dislodge this presumption that the CC's order dismissing her first rescission application, like all official acts, is presumed to be duly granted until the contrary is proved. I'm not going to try and read the Latin, I was never very good at that. The other point is that only the Concourt can make that determination. And that will be, in other words, in the determination of that case that has now been brought. Fourthly, and related to the third point, the objective facts, unlike the speculation, but the objective facts to which I'm going to refer, point to there being very little prospect of the Chief Justice's investigation revealing that one or more of the justices of the court who participated in the decision to dismiss her first rescission application were responsible for any leak from within the CC to Mr. Abramjee, and I'd like to turn to those facts. They are the following. There were two material statements in that SMS. The first one was that by the time it was sent on Sunday the 24th of April, the Constitutional Court had declined to hear Advocate Mkhwebane's rescission application. The second statement was that the decision would be made known sometime in the coming week, but no later than Friday the 29th of April. As the court knows, on the 26th of April, after the matter had been postponed, Advocate Mkhwebane's attorneys, acting with the consent of the other parties to the present matter, addressed a letter to the registrar of the Concourt about the SMS, which culminated in a request for a response to, and I quote, whether the information contained in the request is true or not, unquote. On 29 April, the registrar of the CC responded that, and I quote, the outcomes of the applications for direct access and rescission will be communicated to the parties, and I emphasize, when the court has finalized its processes and made its decision. And those last 4 words, the only possible meaning of that communication is that on 29 April, as at that date, the CC had not yet made its decision. And it follows from that that the first statement in the SMS is false. Now, as things turned out, the Constitutional Court didn't announce its decision by Friday, the 29th of April either. It did so a week later on the 6th of May. And it follows from that that the second statement is false too. Advocate Mkhwebane had questions about the 29th letter and about an interview which the Chief Justice had given apparently a day or so earlier, or reportedly a day or so earlier. And so her attorneys, this time acting not for all the parties but simply for her, on the 3rd of May addressed a letter to the registrar of the CC. In it, after referring to the remarks by the Chief Justice in that interview on the 28th, which she contended showed that the CC's decision regarding her application had already been made, though not announced. That seems to be her position now. She asked the registrar of the CCs for answer to a series of questions at page 80 of that interlocutory bundle. But the key question, and there are a couple of them that are fairly similar, the key question is question 8.6. And I quote, is the factual position that no decision has been made underlined, or merely that the decision has not been announced underlined? That was, the underlining was in the original. Together with the order which the CC handed down dismissing its application, in other words, attached to the self-same SMS, which, SMS, it's stuck on SMS's email. It was on the 6th of May at 3:10 in the afternoon, Friday the 6th of May. The registrar of the CC responded to this letter of the 3rd of May from Advocate Mkhwebane's attorneys. And as His Lordship presiding pointed out, that response starts with the following: please be advised that the court reiterates its response dated 29 April, and then goes on to say, and that in that regard will not engage with correspondence of this nature with the litigant. But the first portion of that, which I've underlined, read in its context of what was said on 29 April, what the question was initially, true or not, said on 29 April, the question that was raised, by reiterating its response. This can only mean that as the 3rd of May, when that question was asked, the Concourt had not yet made its decision. And then there's the final point, that the 9 justices of the Constitutional Court who participated in that decision of the 6th of May did so after the registrar had sent a letter to the parties on the 29th of April. I've already referred to it. I've referred to paragraph 3 of that letter, informing them in paragraphs 1 and 2, firstly, of the court's gratitude, not the registrar's gratitude, but the court's gratitude for bringing Mr. Abdramji's SMS to the court's attention, and that the issues raised were being investigated. And it is, I respectfully submit, to say the least improbable, that in those circumstances, the justices having been alerted to this problem, that any justice who participated in the decision was responsible for any leak to Mr. Abdramji. And why do I raise all of this? It comes back to the presumption of regularity. That presumption, which applies to all official acts, says they are presumed to be valid unless the contrary is proven. And one needs evidence. And the objective evidence, which I have rehearsed, does not rebut the presumption. It's a rebuttable presumption of fact. It does not rebut it. Speculation, I'm afraid, does not, to revert back to outer, provide the compelling case, one very likely to succeed. So if this court were to enter the merits, which we submit it doesn't have to do, then again, this aspect of the matter would similarly fail. I shan't dwell on alternative remedies and the balance of convenience. They're dealt with in our heads beyond saying the following. Ms. Mkhwebane has got alternative remedies. In the first instance, if the committee proceeds with its work and it ultimately finds her guilty as charged on one or more of these counts, and if the requisite majority of the National Assembly thereupon resolves that she be removed, neither of which is a foregone conclusion. The evidence hasn't been led, not one word of evidence has been led yet. And who knows what the majority of the members will make of the ultimate outcome. Much will depend, I suspect, on what is found, if anything, adverse to her. Obviously, if there's no finding adverse to her, that's the end of the matter under the Constitution, because that's the requirement. There's a lot of water to flow under the bridge in this constitutionally ordained, mandated, in other words, mandated in the sense of required process. So there are two big ifs there. If she's found guilty and if there's a resolution adverse to her by the requisite majority, then she may seek judicial review of that decision. That is an alternative remedy which she has. Subjecting herself to this process has a paradoxical benefit for her. She has been charged mainly, but not solely, mainly because several judges, quite a number actually, if one counts the plurality of the Constitutional Court in the CIEX matter, the Reserve Bank matter, have been very critical of her conduct of investigations or her reports in those investigations. There are two of them in particular, or her conduct of the litigation, the review litigation about that. This process presents her with a unique opportunity to clear her name. She can clear the air and clear her name in the process. So there's a distinct benefit for her, and obviously for the Office of Public Protector. As against that, we have the obvious and serious prejudice to the separation of powers and to the public interest in the timeliest conclusion of this process that will ensue if the interim interdict she seeks is granted. That is profound. We are dealing with a very important process here, based on serious charges rooted mainly in strong judicial criticism of the incumbent. And that must weigh heavily with this court, as it did indeed with the Part A court on the previous occasion, and against the granting of this relief.
Yes.
That brings me to the sub judice rule. Now, I've already submitted that the matter which was sub judice is no longer. The second fundamental problem with this, I've already alluded to in another context. In the case of the SMS, the issues that raised have no bearing on the issues for decision by the 194 committee. Similarly, here, the issues raised in relation to the challenge to Rule 129V, that is a solely legal matter, legal constitutional matter. The points raised by Advocate Mkhwebane are twofold, but they're both law points. The one is that the Assembly does not have the authority to appoint a judge to a panel of the advising the Assembly. It's a V-raised argument. That was raised in her application for leave to cross appeal, and in her cross appeal because that application was granted. The second is that there's a separation of powers problem with having a judge on a National Assembly advisory panel. Both of those are constitutional legal issues. There are no factual questions there. The fact that retired Justice Mkhwebane was appointed to her panel gives it bite in this case, but the attack is one of a general legal nature. The matters to be considered by the 194 committee, by contrast, are essentially a factual inquiry into the various charges, what are the facts, followed by the exercise of judgment as to whether the facts as found by the committee constitute misconduct or justify a finding of incompetence as alleged. Those two, there's literally nothing in common with the two. So in what sense can it be said that the sub judice rule is infringed if the committee carries on with its hearing evidence from witnesses to ascertain the facts, and then considers and decides the question of her guilt or innocence of the various charges levelled against her? The committee does not have to reflect for a moment on the issues of whether the Parliament had the power to make a rule saying a judge could be on such an advisory panel, and whether if it did, that would infringe the separation of powers. They simply don't arise. So on the facts, the sub judice rule doesn't arise. And then
Insofar as it relates to the processes in the National Assembly, that had passed already.
Yes.
Because the rules already went through the Assembly.
yes, and
And the only portion where it changed was the excision by the Constitutional Court of the proviso.
correct, and that relates to the process going forward. And so the thing is that is, factually speaking, that's water under the bridge. Justice Mkhwebane chaired that committee. They did their work. They finished and reported in February 21, as memory serves. That's history. It's a jurisdictional fact that such thing had to be done. It was done. And there's been litigation about that. And crucially, that part of the litigation is attacked only on these two legal bases, which are really, they just aren't issues that are going to arise. And the third problem is
issues that are going to arise in the work of the committee, you mean?
Yes. And the third is that one has the finding of the full court. The three litigants raising this were parties to the previous case. Advocate Mkhwebane, the UDM and the ATM.
I haven't seen the name of the UDM mentioned in that case.
That's right. I don't
the
think
judgment, because I don't have the
papers.
All the participants except the ones that are named in itself. So I know there were 10 or so respondents,
22.
but only a few are mentioned.
Yes.
The ATM, the public protector, the speaker,
Yes.
the president, and the DA.
Let me just check
They
one.
mentioned in the judgment.
Yes.
And that's where my comment came from this morning to say to you, the president abided. See.
I just want to check one document, if I may. I'm in the wrong file.
Because the copy of the judgment that
So there's no copy of the Part A judgment in the papers. It's in the bundle.
No, I have that. That's from 587.
But the Part B judgment is in volume 7. And at page 623, the parties are listed.
Yeah.
And
So there we can see it.
all political parties being the 9th to 22nd respondents. That's at page 6, should I say 623 and 624. It's MNTV That's a tongue twister for me. NMN1.
You'll find it. Yes, you may proceed.
So we have a finding. This is the part A judgment. Yes. We have a finding by the Part A court in paragraph 108, to which His Lordship presiding referred my friend Mr. Masuku yesterday, that the sub judice rule does not preclude, and I'm quoting, the members of the National Assembly from carrying out their oversight functions and the holding of office bearers of Chapter 9 institution accountable in terms of Section 194 and the new rules. It's quite a strong finding, and it would encompass a case which is not like we have at the moment, where, let's say, there's judicial review of a report by the Public Protector, and that has also founded a motion for the removal of the Public Protector. There could be a serious allegation, let's say there's already been a serious finding by court adverse to the Public Protector. What that finding says is that courts, you've got your work to do. National Assembly, you've got your work to do. And the fact that there may be an overlap between the issues, Rule 89 doesn't preclude that. That's the finding of the Part A court. That's binding on this court unless clearly wrong. It doesn't bite in this case for the second reason that I gave, namely that there isn't an overlap at all in the issues here. So this is actually an easy case to avoid any controversy around Rule 89. One needs ultimately to consider the rationale for that. We deal with that in paragraph 85 of our heads, and I'm not going to dwell on that. So we submit there's no merit in the sub judice attack. As far as the alternative reliance of Uniform Rule 45 and Section 172 of the Constitution is concerned, just to start with 172(1)(b, as the court will know from the Part A notice of motion, there's no reference to 172(1)(b) there. But as the judgment records in argument, my learned friend in reply, as I recall, invoked Section 172(1)(b), Jafta J's judgment in the Gordon case, just and equitable discretion, and the court dealt with that and held that the justice and equity of the case didn't warrant the stopping Parliament from carrying on with the impeachment process for essentially the same reasons that the balance of convenience weighed heavily against and also obviously the prima facie right problems in the mainland. So we submit that doesn't really add anything. The considerations are ultimately no different. One has to consider clearly the separation of powers, harm that would be caused by any intellect when deciding on the justice and equity. You have to look at the strengths of the case. You have to look at the alternatives open to the litigant seeking the relief to being given the interim relief. As far as Uniform Rule 45A is concerned, we submit firstly that and I'm now focusing, I'm in a world where I'm imagining that we have this first rescission application is somehow on the table. The first thing about that is that when the Constitutional Court reversed the full court Part B's order upholding the challenge to the constitutionality of Rule 129V, what it did was replace it with an order dismissing that challenge. So it changed the order of the High Court to one dismissing a challenge. And the thing about that is that an order which dismisses an application without more, let's say no costs, and in fact there were no costs ordered in favour of the Speaker. But an order dismissing an application is not one which has an operation and an execution which is capable of suspension, whether in terms of Uniform Rule 45A or 172(1)(b. It doesn't change the status quo in any way. It's where the order changes the status quo. Pay Mr. Bloggs the plaintiff 100. That's an order which operates and has an execution which is capable of being suspended pending the outcome of an application under Rule 45A for rescission, or this alternative under 172(1)(b). Assuming we're wrong in that, and this court were to issue an order, such as is sought here, suspending the Constitutional Court's order in relation to 129V, that in itself would just have to be stated to cause one's hackles to rise, or your hair, the hairs on your arm to go, whoa, what's this? I'm being asked as a High Court to suspend the operation of a Constitutional Court order. But that's what they're asking. But what would the effect of that be? So that would revive the status quo immediately before the Constitutional Court granted that order, the order dismissing the challenge to 129V and replace effectively. And what was that status quo? Well, that is the status quo created by the fact of an appeal against that order of the High Court. And Section 18(1) of the Superior Courts Act says that that appeal had the effect of suspending the High Court's order anyway. That's why Mr. Tsenoli had to consider and gave the advice that he did. He knew that, yes, the Part B Court had declared 129V unconstitutional and 129AD3's proviso. But he also knew that an application for leave to appeal had been lodged with the Constitutional Court. There was also a conditional application here in this court to appeal to the SCA in the event that the Con Court refused that. But we can leave that aside. There were two applications for leave to appeal, one contingent on the failure of the other. But the effect of those was to suspend the operation and execution of the High Court's order declaring those two rules invalid. So if the applicant were to succeed in persuading your lordships to issue an order setting aside the CC's order, the status quo which would be restored would be exactly the one that Mr. Tsenoli was confronted with, and that was that the inquiry could notionally go ahead. He decided to advise the committee against doing that because of the potential implications of an adverse outcome in the CC. But for present purposes, what's important is that turning the clock back doesn't assist Advocate Mkhwebane in the slightest, because all you would then have is an order of the High Court invalidating two rules, which itself is suspended pending the decision of the Constitutional Court, which must notionally still be taken. And the last problem, and this relates specifically to Uniform Rule 45, I've already made this point, that with respect cannot operate in favour of a particular litigant, one individual, where one is dealing with an order in rem. The order that she sought is that a rule of general application be declared unconstitutional. And if that position were to revive, which we submitted wouldn't anyway because of Section 18(1). So that's why we submitted this part of the case is a non-starter. It's conceptually a non-starter. The order, basically, the order of the High Court dismissing the application, which is effectively the order that the Constitutional Court transplanted in, is not one capable of an operation and execution which can be suspended under 45A. It's in any case an order in rem which is not capable of so dealing. And if the court were to do that, our third point is the result would simply be to restore the Section 18(1) position immediately prior to the Con Court order. But in any case, the merits are exactly the same merits as the pre-1. The court will have to consider all the same factors, and for all the reasons we've given there, one could not, with respect, grant an order in this case. I'm told that it's 11 o'clock. I've got two topics to deal with. May I speed through those? I shan't be more than 15 minutes, and I apologize to my friend, Ms. Pillay, online, because I'm now eating into her time. So the first concerns the claim for an order directing the Speaker to withdraw her 10 March 22 letter to the President. That is in the notice of motion at paragraph 1.3. It's said to be pending Part B, but it does, on the face of it, seem to us to be final relief. So before dealing with the grounds of that, I'd like to just pose the following question.
Well, they both 1.3 and 1.5 that, or 1.3 and 1.5 that Ms. Bade will deal with. It's mandamus that sort.
Yes. They're final orders that are being sought. It's not actually interim relief, but we make nothing of that. That's the relief which has been sought. It's conceptually wrong to include it in a paragraph like this. It should be free-floating. But I wish to pose the following question to the court for its consideration. And I do so on the basis of what Advocate Mkhwebane says in her replying affidavit at page 973. The volume number is volume 10. It's in paragraph...
Let's go back to 1.3 and 1.5. I know now
Yes.
I'm eating into your time. Returning to the original application in 2107 and the relief sought there, where for an interim interdict was phrased in relation to the Speaker
Yes.
from taking any further steps in the implementation of processes envisaged in section 194 of the Constitution and conducted in terms of the impugned rules.
Yeah.
So that would include, because the letter that she wrote was to inform the President that the process have started effectively. And that's the letter to be withdrawn. So that would have been covered under 2 in the previous application as well.
In read literally, it would.
And the alternate to prayer 2 in that case in 2107 was interdicting those respondents, which included the President and or their members, who have a conflict of interest from voting and or participating in any way in the process carried out in terms of section 194 of the Constitution and the rules. So the conflict of interest of the President was also raised there by implication.
Yes. And indeed, it was raised expressly as well. At that stage, the factual basis...
No, the affidavit was next year.
The
His answering affidavit was the next, or his explanatory affidavit, because he abided the decision.
Yes. It was the Busisiwe case.
Yeah.
That was the factual basis for the contention. So
Yes.
if one gets to the merits of this, the first point I just wish to emphasize, and this is the applicant herself speaking at volume 11, 973, 78.1, and I quote, "The issue as to whether the removal proceedings has started requires objective determination. The subjective opinions of the Speaker and the President are not decisive." That's in her reply and affidavit. It's an objective question, and the opinions of the President and the Speaker are not decisive. And I submit that with respect is correct. Because what's underlying this is a contention that the Speaker was mistaken to report to the President that the committee had restarted its work, if I can put it colloquially. And what's underlying the contention that my learned friend Ms. Bade will deal with is the President is wrong to have initiated the consideration of her possible suspension because the committee hasn't yet started. The argument, as I understand it, is that will only happen when the evidence of the first witness is led in or heard by the committee. But if it's an objective question, the question that I just lay before your lordships is this: what is the utility of directing that these letters be withdrawn? Because what is really being sought here in this notice of motion is 1.4. The President is prohibited from taking any steps in pursuance of the suspension of the applicant. That's the issue that my learned friend Ms. Pillay will be addressing, is whether The President should be prohibited from doing that, either because it's premature, which is the one argument as I understand it, and that's where my client gets drawn into this issue in a limited way because of this letter, or because the President is conflicted, a matter in which I make no submissions whatsoever. But what is if she's right, as she's pleaded, that it's an objective question.
And the utility, insofar as it relates to the President, is different as to your client, because it doesn't really affect your client further if the order is made that the 194 process is paused. Insofar as it relates to the President, it might have an effect on the Audi and the timelines and so forth.
Yes.
That's the argument as I understand it.
Yes, and I'll leave that to Ms. Pillay to deal with, but it just seems to me that it's a brute and fulman. If it's an objective question, the court will obviously deal with the issue of whether this is all premature or not in its judgment, if it gets to that part of the case. Whatever the Speaker might have informed the President and the President might have done, the bite will be whether the President is now vested with the power to suspend or not. Has, to put it colloquially, has 194.3a kicked in? That's the issue insofar as it relates to my client.
But you say if we're with you on some of the other grounds, then we don't even get there.
We don't.
It's more relevant to the President's case.
And that really brings me to the cost side of things. So there's an allegation by the advocate Mkhwebane, and it was persisted with my friend yesterday, that there was something untoward about this. Advocate Mkhwebane at para 137 on page 49, volume 1 says, the Speaker's writing to the President was clearly accompanied by bad faith, improper motives and bias. She's hell-bent, that being the Speaker, to press ahead with the impeachment process in para 31.
Mr. Breitenbach, you've made your submissions on the costs in your heads.
Yes.
So you don't need to address us further on that.
Thank you. May I just take a moment to consult my juniors?
On the face of it, insofar as it relates to the parties, once we've made a factual decision, we have to apply the principles. That's crystallized.
Yes.
And the Constitutional Court has been clear about punitive orders and cost orders and punitive cost orders against functionaries, where it related to the public protector as well. So we will have to determine the factual basis after we've heard everybody on the facts, and then we just have to apply the law to that.
Yes, we've made our submissions.
It's a discretionary power that the court has, how to apply the cost. So you've made your submissions in
Thank
your
you.
heads. You've countered the argument by Mr. Mpofu in your head, so we don't need to be any further.
Thank you. If he does raise something new in reply when he's apparently going to address this for the first time to your lordships, I will beg your leave to deal with that in a note, but I'll let that.
And whilst you're here, and I know Mr. Masuku is not virtually present, but I saw Menzies and Milani on the virtual platform, that if we're going to grant parties to file supplementary notes, it must be filed by Sunday afternoon. We intend working on the weekend and to try and prepare a draft by next week.
Thank you.
Amongst ourselves. And then we'll have to polish it up.
As you know, my lords, my instructions therefore are to ask that this application be dismissed with costs, including the costs of one senior and one junior counsel. Thank you. Those are our submissions.
Thank you. So it's 11:15 now. I saw Advocate Pillay come in. Advocate Mpofu, you
Yes.
have something pressing?
Yes, my lord, yes. In fairness, while Mr. Breitenbach is here, that he has just foreshadowed it, I thought it might be useful for him to note that insofar as he raises the Rule 28 point, which is a technicality, that we will raise that issue. So if he mustn't go too far.
Yeah. No, when he leaves, he'll go onto the virtual platform in his chambers in any event.
No, I don't mean literally.
Yeah.
I'm just saying he must be mentally prepared to deal with that if he wants to.
Yeah. Okay. All right, so we'll take a quarter of an hour adjournment so that we can change the batting order, and Advocate Pillay and her team can take the front row. I don't know whether both your juniors are going to chambers or whether...
Yes, we are all retiring herdmen.
So you can be excused in the meantime, and then I take it we've arranged a time for Advocate Mdntv later in the day.
Yes.
And hopefully we can push through to what's the customary lunch break. Might be out of kilter with the normal times with Advocate Pillay, and then we can get Advocate Mdntv in the afternoon and then finish off with a reply later earlier this evening.
Yes. Thank you.
Thank you. The court adjourns. Just ensure that you mute the microphones. The person that's operating in Mrs. Davids' chambers can ensure that the microphones are muted. We don't want to have the same problem as yesterday. Thank you. The court adjourns.